And key instruments within that, the Universal Declaration of Human Rights 1948 is an important human rights instrument, but it's non-binding. For binding provisions, you'll look to instruments I'll refer to in a moment. Its form is that of a resolution of the General Assembly of the UN, then relatively newly founded in 1948. Next, a very important instrument that provides essentially the basis for UK asylum law, albeit that works through different levels and parts of the law, with domestic law and EU law as well. The 1951 Convention relating to the status of refugees, which was amended in 1967 by a protocol. The key definition, Article 1A2, a refugee is a person who, owing to well-founded fear of being persecuted for one of those reasons, race, religion, nationality, membership of a particular social group or political opinion, is outside the country of his nationality and unable, or owing to such fear, unwilling to avail himself of the protection of that country, or who, not having a nationality, being outside the country of former habitual residence, is unable or owing to such fear, unwilling to return to it. The key is that someone has to be outside his or her own country and to have what's often turned into an acronym, WFF-PCR, well-founded fear of persecution for a convention reason. The reasons itemized there are called the convention reasons. So you're either outside the country of your nationality and a refugee by meeting that definition, or you have no nationality and that definition has to be considered by reference to where you've been formerly habitually resident. It's also provided in the second paragraph I haven't set out there, if you're dual national, you have to have a valid reason for not availing yourself of protection from every country of nationality. Other important provisions to enable you, this is what I've done throughout, to enable you to identify them and look them up as questions arise. Article 1C, cessation of status, how you stop being a refugee. Article 1D, Articles 1D through 1F, exclusion or non-application. So if you go back to being protected by your country of nationality, for example, you cease to have status if there is sufficient case that you've committed a war crime, you cease to be, you are excluded, for example, or if you're a Palestinian who has protection from in elements of the UN in the Middle East, you're excluded from the refugee definition. The 1950, so the key things that happen for a refugee, according to, because of the 1951 Convention. Article 32, refugees are protected from expulsion if they're lawfully present. Article 33, critically important, they are protected absolutely from being sent back to a place where their life or freedom would be at risk, which is called refoulement, but, excuse me, but that is inapplicable, and this is the quotation at the foot of page 1, for a person where there are reasonable grounds for regarding the person as a danger to the security of the country, or who, having been convicted by a final judgment of a particularly serious crime, constitutes a danger to the community. Those people, Article 33(2) doesn't stop people being refugees, but those people can, in fact, at least as far as the Refugee Convention is concerned, be returned even to a country of persecution. As you'll find, those people are that are protected from that, not by the Refugee Convention, but by human rights provisions. Article 54, the Convention relating to the status of stateless persons. Stateless persons don't have a right to protection from refoulement separately from the Refugee Convention. They may also qualify under the Refugee Convention. But the definition is important to know, because statelessness, or the term stateless person, is important in contexts like deprivation of nationality by section 40(4) of the British Nationality Act 1981. It's a barrier to depriving someone of nationality on the basis that it's conducive to the public good, if that would render them stateless in the view of the Secretary of State. And it's and there are provisions in the immigration rules which provide for leave to remain to be granted to some people who are stateless and can't return to another country. So the 1954 Convention, the critical thing to have is the definition there. That definition is applied generally elsewhere in international law and in domestic law. And international human rights law. The main instruments: International Covenant on Civil and Political Rights, so it's a typo there, 1966, came into effect in 1976. Key provisions which generally mirror equivalent provisions of the European Convention on Human Rights. They're not identical, but in the respects I'm going to deal with, they're very similar. Article 6, there is the right to life. Article 7, the prohibition of torture or cruel, inhuman, or degrading treatment or punishment. Those equate to Articles 2 and 3, respectively, as you'll know, many of you, in the European Convention on Human Rights. And other important instruments there: the Race Discrimination Convention, the CEDAW, the Convention for the Elimination of Discrimination Against Women, all forms of discrimination against women, the Convention Against Torture and Other Cruel or Inhuman or Degrading Treatment or Punishment, the Convention on the Rights of the Child, the Convention on the Rights of Persons with Disabilities, 2006. That's the list. Further, our regional body, the Council of Europe, different, of course, from the European Union. The Council of Europe is linked to instruments related to human rights, including the European Convention on Human Rights and Fundamental Freedoms 1950. I've listed the critical 3 provisions that tend to come into consideration in relation to immigration, and the Council of Europe Convention on Action Against Trafficking in Human Beings, 2005. Further, there is EU law. So the EU Charter of Fundamental Rights contains some relevant provisions. In practice, you don't need to know those very well or refer to them very often, because they tend simply to back up provisions that are established but elsewhere, notably by the European Convention. And a couple of important instruments of EU law. First of all, at the foot of page 2, Council Directive 2004/38 EC, which is known as the Citizens Directive, and that's mostly transposed into domestic law. We will look at the Immigration European Economic Area Regulations 2016, which are the main means by which those are transposed into domestic law in England and Wales. Next, the Council Directive 2004/83 EC, minimum standards for qualification as refugees or persons who need international protection. The Qualification Directive. Critical elements there. That uses as the basis of the system for international protection of refugees, the 1951 Convention. So it's looking to the 1951 Convention. there is some reinterpretation or some attempt to reinterpret the extent of the 1951 Convention definition in certain limited respects. But in general, the Qualification Directive is seeking to get to the same place as the Refugee Convention, and indeed to provisions in the immigration rules and regulations, which represent part of the domestic system for this protection. So Article 13, member states shall grant refugee status to a third country national or stateless person who qualifies as a refugee in accordance with chapters 2 and 3. So those are the chapters going to the establishment of who is a refugee. Article 15, relating to subsidiary protection. So separately from whether you're a refugee, you're protected from serious harm, which includes death penalty or execution, A, torture or inhuman or degrading treatment or punishment in the country of origin, which you'll see broadly mirrors the provisions of the Covenant for Civil and Political Rights and the European Convention on Human Rights, and the final provision, Article 15C, serious and individual threat to a civilian's life or person by reason of indiscriminate violence in situations of international or internal armed conflict, which is a subsidiary provision designed to provide protection from people facing return to states where they're not necessarily protected by refugee provisions or by individualized human rights provisions, but there is a level of indiscriminate threat due to armed conflict. Next, domestic law. The critical bit of domestic law, the top bit of domestic law in England and Wales is statute. That is laws passed as primary statute by Parliament. The critical statutes, I've listed them there. The Immigration Act 1971, the Nationality, Immigration and Asylum Act 2002, the UK Borders Act 2007, the Borders, Citizen and Immigration Act 2009, and the Immigration Act 2014. And we'll see as we go through a bit of what those do. And next, statutory instruments. So statutory instruments are secondary legislation which are put before Parliament. Often the minister has been empowered to create and put forward statutory instruments which can be called regulations and or as well as statutory instruments or secondary legislation. And there is in the immigration context something else, which is called the immigration rules. The immigration rules, they're neither a statute nor are they a statutory instrument. Changes to the immigration rules have to, the immigration rules, their existence is mandated, as we'll see, by statute. So they have to exist, and the Secretary of State has to obtain, the government has to obtain parliamentary approval for an amendment to the immigration rules. But generally, they're amended a lot. They're amended very frequently, and they don't go through the same sort of parliamentary scrutiny that a statute or statutory instrument goes through. Changes to the rules are put into a document called a statement of change to the immigration rules. They go to the parliamentary library where a debate can be brought about, but in practice, debates on changes to the immigration rules are strikingly rare. The legal framework. So looking in a little more detail at the critical blocks of domestic law. That primary legislation, first of all, the 71 Act, The 71 Act, I've listed the most critical sections to know about as building blocks for the system. So Section 2 sets out who has right of abode. You know, right of abode is the legal right to live and remain and enter the UK. Section 1 has already set out what the effect is if you have right of abode. That is, you're free from immigration control. Other people are subject to immigration control. I mean, there's a limited exception for EU citizens, and there's an exception for diplomats, which we don't need to cover. I'll refer to the position of EU citizens as we go through. So Section 3.1, provision for control. That is, there's a requirement for someone to obtain leave to enter or remain in the UK if they don't have a right of abode. Section 3.2 requires the Secretary of State for the Home Department to lay before Parliament changes to the immigration rules. And I've referred to the negative resolution procedure that is used for those changes. So the immigration rules are a fairly exceptional document, being neither primary nor secondary legislation, but required to be in place by a statute through Section 3.2 of the 71 Act. Something that's extremely important dealing with cases is that certain people, I mean, if you, in general, look at the provision as and when you need to, or before you need to, but in very general terms, someone who has leave to enter or remain and who applies for variation or extension of leave to enter or remain, that is extended automatically whilst the application is outstanding and then whilst an appeal process is underway. And that happened through Section 3C. It's called Section 3C leave in common parlance. Sections 3.5 and 5.1 provide the basic mechanism for deportation. It's quite useful to this structure because the Home Office has built on this but hasn't destroyed it. And in a limited number of cases, it may still apply without other added provisions that I'll come to. By section 3.5, a person is liable to deportation if the Secretary of State deems his deportation to be conducive to the public good. I can leave it there. That's the primary part of it. And by Section 5.1, a person who is liable to be deported where a person is liable to be deported, the Secretary of State may make a deportation order, that is, an order requiring him to leave and prohibiting him from entering the UK. And the deportation invalidates any leave to enter or remain in the UK given before the order is made or whilst it's in force. That's Section 5.1. So under the basic structure, there are two steps. One is whether you're liable to deportation. The next is whether a deportation order is made. And as many of you will know, deportation action often attracts appeal under the present appeal structure, to which I'll come. That is generally that is directed at any human rights claim, or rather at the refusal of a human rights claim attached to to deportation. That is, the individual will appeal on the basis that the deportation represents a disproportionate breach of human rights, or a breach of human rights where proportionality doesn't arise. Next, that's Schedule 2 provides for examination, detention of individuals in the course of the immigration process. The European Communities Act 1972, of course, we live on relatively borrowed time, and matters will change, but they may not change immediately so much as might be thought. I won't get into that, but the European Communities Act is domestic law, but it's by domestic law that key parts of EU law are given supremacy over UK law. With the Human Rights Act, generally human rights treaties are not directly binding in the UK, but the Human Rights Act incorporates into UK law critical parts of the European Convention on Human Rights, including Articles 2, 3, and 8, which I've already referred to. That is the right to life, the prohibition on inhuman or degrading treatment or torture, and the protection for private and family life. Section 3 of the Human Rights Act requires courts to interpret primary and secondary UK legislation or England and Wales legislation so that those are compatible with the articles of the European Convention on Human Rights, which are made part of UK law by the Human Rights Act. Sections 4 and 10 allow courts to issue a declaration of incompatibility where they can't interpret primary or secondary legislation as compatible with incorporated provisions of ECHR. Section 10 gives a government minister a power to make a remedial order in response to either a declaration of incompatibility or a ruling of the European Court of Human Rights. And Section 6.1 provides it's unlawful for a public authority to act in a way which is incompatible with the convention right. This is one of the two means by which the European Convention is, for purposes of immigration, incorporated into domestic law. The first via the Human Rights Act itself, the second via the appeals provisions in the Nationality, Immigration and Asylum Act 2002, to which I'll come in a moment. And the approach to the question at Section 6.1 in the Human Rights Act 1998, it's unlawful for a public authority to act in a way which is incompatible with the convention right. I've set out the stages identified in the decision of Rasgar against Secretary of State by Lord Bingham, the late Lord Bingham. The next critical statute, Nationality, Immigration and Asylum Act 2002. So the most critical element here is Part 5 of the Act. The 2002 Act is the much patched and worn and mended provision which provides for the right of appeal. That's at Part 5. It's essentially, in its present form, you essentially have a right of appeal on the basis that the decision isn't compatible with the Refugee Convention or with the humanitarian protection rubric in the qualification directive, which you've already seen, or with ECHR, and the mechanisms for appeal and whether the appeal is suspensive of removal, whether it takes place in the UK. I've pointed to those there. Next, the UK Borders Act 2007. What's critical there is a scheme. I'm not going to go fully through it at sections 32 to 37 for automatic deportation. What that is meant to do, you've seen that back in the 71 Act, you had section 3.5 that provided for someone to be made liable to deportation, and then you had the provision for the Secretary of State to make a deportation order. That left it as a matter of discretion whether the Secretary of State would make an order in any particular case. The key drive of the 2007 Act is to insert a scheme that provides that in certain circumstances there is no discretion, that the Secretary of State has to make an order. That's why it is referred to generally as the automatic deportation scheme. And the key provision, section 32, foreign criminal is a person who's not a British citizen, who's convicted of an offence, and who either is sentenced to imprisonment for at least 12 months, or the offence is one that's specified and as a particularly serious one, and the person is sentenced to a period of imprisonment. And the grounds on which an individual is able to contest that, it broadly include that it's inconsistent with the Refugee Convention, and that it's inconsistent with the provisions of the Qualification Directive or the European Convention on Human Rights. The Borders, Citizenship and Immigration Act 2009, at the very basic level, at the starter level, what's critical to know is section 55. That is, there's a duty on the Secretary of State or on an entry clearance officer to treat the best interests of a child as a primary consideration in making any decision regarding immigration or otherwise within the purview. It's been extremely important in deportation, but it's not limited to deportation. It's one of the most important positive innovations into UK law of the last decade or so. The border, so that's the 2009 Act, the Immigration Act 2014, attempted to introduce a deport first, appeal later system whereby the Secretary of State certifies a claim and that individual can only appeal after deportation. That has attracted challenge, and I'll leave the detail if I may, but it's important to know that that is a primary aim of the 2014 Act, acting by amendment of the 2002 Act. In addition, and you have this on page 6 of the handout, it brought into force a new Part 5A to the 2002 Act, so public interest considerations relating to Article 8 ECHR. This is part of a process I'm going to refer to in a moment, by which the Secretary of State, both in relation to deportation and away from deportation, has attempted to limit the width of the judgment that judges might make regarding whether an individual's removal or deportation represents a disproportionate breach of Article 8. Article 8 arises in almost every deportation case. And so is a major concern, but equally it applies in most overstaying cases and in very many others. So you've got the reference to the new section 117A and so on, and the Court of Tribunal must have regard to the public interest question, which means whether an interference with the right to respect for private and family life is justified under Article 8.2. Secondary legislation. So secondary legislation, delegated legislation, such as the critical instrument for most purposes, most of the time, in relation to rights under EU law. They originate from EU law, mostly from the Citizens Directive, which I've identified, but they're transposed through into domestic law by regulations. And the current regulations are the Immigration European Economic Area Regulations 2016. I've set out the critical parts rather than individual provisions, because again, I'm trying to identify very basic underlying key concepts and the big building blocks, rather to go into the detail of individual provisions, given the time available and the level of this. And the immigration rules. The immigration rules are sometimes referred to as HC 395, which means House of Commons paper 395, and numbers are given to statements of changes of the immigration rules. Important parts of the rules for general experience. Part one, the various general underlying provisions. Visitors are dealt with at part two. People under the points-based system, entrepreneurs, investors, skilled workers, students at 6A. 7 contains various other provisions, but a critical one is found spread across paras 27A through 27D, long residence. In general, so with exceptions, depending on circumstances, but in general, it's a correct statement that an individual will be entitled to indefinite leave after a period of continuous lawful residence in the UK of 10 years. And long residence is extremely important in casework. The provision as regards family members, 8, and I'm sorry because family are now dealt with at Appendix FM of the, are also dealt with at Appendix FM, which is Article 8 and family members. General grounds for refusal, that is the grounds on which the Secretary of State will refuse or can refuse to grant entry clearance or leave to enter or remain where someone otherwise satisfies the rules. Those are at part 9. And asylum. So the basis, the basis to asylum law is an understanding of international refugee law, that is the 1951 Convention, which you'll remember is important as a basis for the Qualification Directive. And that's all translated through into the immigration rules. A couple of critical paragraphs, 334. So grant of asylum, the requirements for grant of asylum in the UK. You're in the UK, you qualify as a refugee under the 51 Convention. There are no reasonable grounds to regard you as a danger to the security of the UK, and refusal would require you to go to a country in which your life or freedom would be threatened on account of race, religion, nationality, political opinion, or membership of a particular social group, which I've described as the convention reasons. And also tucked up in the asylum section, the provisions regarding refugee family reunion at paras 352A through D. It's important that those are very limited, and that you may have to consider Article 8 outside in the context of refugee family reunion, because people don't fit the very narrow entitlement thresholds. In particular, a situation you often see in the refugee family reunion context is a family where there are children of the family, some of whom are aged just over 18, but still part of the family. And the immigration rules themselves only provide family reunion for those who are under 18 at the date of application. So the child who has lived all his or her life with the family, who's a student, who hasn't left home, who hasn't married or established any different unit, is excluded, is not entitled to refugee family reunion under the primary rules. And so you can end up with family groups where several children are entitled under paras 352A through D, and the partner or spouse is the other parent of the child, is entitled under para 352A through D, but some children's cases have to be argued under by reference to Article 8. Provisions relating to deportation are set out in the immigration rules at Part 13, and I referred to the Statelessness Convention. The provisions by which someone who is a stateless person can obtain leave to remain in the UK are under Part 14 of the immigration rules. Some important appendixes. So Appendix FM is family members in Article 8. Appendix FMSE is the specified evidence standards to prove matters that you have to prove by reference to Appendix FM. In addition, I referred to the EU settlement scheme. The EU settlement scheme is in Appendix EU. And again, like other parts of the rules, perhaps even more so, some of these are very frequently amended. The EU settlement scheme has been amended many times since it became effective in August 2018. Those are available online. The complaint you could make about this is it's a labyrinth of different levels of law and sources of law. This is Ellis Wilford's language, but it's not unfair language. Byzantine, frequently mind-boggling, ever-changing. So I'm going to move on. And I think that at the start of page 8, apologies, failed to update that. I would guess there have been considerably more changes than that in the last 12 months, including changes to Appendix EU. So I wanted to deal in slightly more detail with Article 8, because Article 8, if you're doing casework, or Article 8 applies potentially to almost everyone in the context of immigration, including the context of deportation. And so it's a useful foundational area to have a slightly deeper knowledge of from the start. So Article 8 provides the right to protection for private and family life, the critical provision. I'm going to read from the schedule, or rather from Appendix 2 to the Human Rights Act 1998, that lists and transposes the European Convention on Human Rights provisions into domestic law. So Article 8.1, everyone has the right to respect for his, I'm going to add her because it's my preference, to limit to one gender, private and family life, his home, his or her home, and his or her correspondence. Article 8.2, there shall be no interference by a public authority with the exercise of this right, except such as in accordance with the law and necessary to democratic society, in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or the protection of the rights and freedoms of others. So it's not an absolute right, it's a right that the state is permitted to restrict, but it's only allowed to restrict it in a way that is lawful and justified in a democratic society by reason of one of the protected interests and is proportionate to the protected interest. As I explained, the Secretary of State has attempted in recent years, since July 2012, to, in essence, channelize, to provide a channel or a silo within which Article 8 is to be decided. The courts, in essence, have protected that and have said that there's always access, if necessary, to a wider Article 8 consideration. But the decisions of the higher courts have often been fairly restrictive in their language. There's a serious advantage to being able to bring yourself within the rules rather than to have to argue that you're outside the rules, but still within Article 8. So the provision as regards private life, private life includes your life in society with others. It includes the right to physical and moral integrity. The key provision, paragraph 276 ADE. So you have to be outside any of the usual grounds for refusal, such as criminality or not conducive to the public good. You have to have made a valid application. You have to have lived continuously in the UK for at least 20 years. This, in essence, small Roman 3, is the first of a series of alternatives. So, having lived continuously in the UK for at least 20 years, discounting any period of imprisonment, if you otherwise qualify, is a basis for leave under 276 ADE 1 small Roman 3. Or the next one, you're under 18 and you've been in the UK continuously for at least 7 years, discounting any period of imprisonment, and it wouldn't be reasonable to expect the applicant to leave the UK. Next one, small Roman 5, aged 18 years or above and under 25 years, so quite a narrow window. In casework, it's very important if you're assessing or advising individuals who are under 25, whether at any point within the window they'll satisfy the rubric. So you're between those two ages and you've spent at least half your life living continuously in the UK, again discounting any period of imprisonment. And the last provision, a very important one in a substantial number of cases. So the person has lived continuously in the UK for less than 20 years, but there would be very significant obstacles to the applicant's integration into the country to which he would have to go if required to leave the UK. It's important to realize what the Secretary of State is doing there, because under pre-existing authority, decisions of the European Court of Human Rights and domestic decisions, Article 8 is much wider, and Article 8 remains much wider despite this limiting provision. Within a broader consideration of Article 8, obstacles to return would be part of the consideration, but they wouldn't be the single prioritized consideration. What the Secretary of State seeks to do by Section 276 ADE1 small Roman 6 is to prioritize a single issue of obstacles to reintegration, in essence, eliding what would otherwise be relevant considerations. And those relevant considerations include, you've been in the UK for many years, you're well integrated in the UK, you've given considerable public service in the UK, or there are particular matters that tie you to the UK, medical or personal or other matters. So this is quite a narrow, this is meant to be a narrowing or the rubric or the creation of a silo by the Secretary of State. I mean, ultimately the Secretary of State is able to create her silo, but she's not able to say, this is the only way you can qualify. I mean, you have to look then to Article 8 outside the rules. So judicial interpretation, Camara against Secretary of State, the critical early case on this, very important to know, the concept of integration is a broad one, not confined to mere ability to find a job or sustain life. It's not appropriate to treat the statutory language as subject to a gloss, and it calls for a broad evaluative judgment to be made as to whether the individual will be enough of an insider in terms of understanding how life in the society is carried on and the capacity to participate in it, so as to have a reasonable opportunity to be accepted there, and the description, the delineation of the test goes on. Sadly, judges very often are, in my respectful view, disloyal to the Camara test, and very, very willing to deem there not to be significant obstacles, in essence, to elevate the test for significant obstacles. And that's consistent with some decisions of the upper tribunal, and indeed with some, though not all, decisions of the Court of Appeal in the area. Next, family life. So Article 8 protects private life, potentially protects private life and family life. Family life, Appendix FM to the immigration rules covers family life. Adult dependent relatives are also covered, but again, I've referred to the way the Secretary of State tries to create a silo in relation to Article 8 by Para 276 ADE1 small Roman 6, and it's the same with adult dependent relatives. They are not permitted to apply within the rules from in the UK. They have to apply from outside the UK. A subcategory, a practical subcategory of Article 8 cases you see are cases where adult dependent relatives have come to visit family members in the UK, but their personal situation has changed, very often through changes to their health whilst they're in the UK, that necessitate reliance on Article 8 outside the rules by an adult dependent relative. Appendix FM defines partner as including spouse, civil partner, fiancé, or proposed civil partner, or a cohabitee who's in a relationship akin to marriage or a civil partnership with the other partner for 2 years. And I haven't explored those provisions at length. I have set out some of the key decisions, not all the decisions. You could easily fill a couple of hours just with a survey of the case law on the key Appendix FM tests and categories. But I've set out the basic approach of the superior courts. In Nagre, Mr. Justice Sales, now Lord Sales, that's the critical dictum establishing that the sector state isn't able to close down or to siloize the application of Article 8. And then critical provisions. I'm so sorry. The most important cases have been a trio of decisions of the Supreme Court in cases called Hesham Ali and MM Lebanon and Aguiarco, relating to Article 8. As you can see, there has been a significant flow of questions upwards in relation to Article 8, which reflects the fervor with which the sector state has ceased to, you could pejoratively say, close Article 8 down, and the fervor with both by challenging decisions in favor of individuals and by resisting, often very well supported applications and appeals by individuals. I've set out some useful basic resources at Section C. So the British and Irish Legal Information Institute, Bailey, excellent website, gives you free access to all case law, decisions of the Supreme Court, of the Court of Appeal, of the Upper Tribunal. Doesn't give you any guidance as to the content of the law. I'll refer to some of the key books in a moment. Next, the Free Movement website for legislation. Unfortunately, legislation sometimes isn't fully up to date, but there is a site, www.legislation.gov.uk. And if you're a lawyer or you otherwise have access to a law library, you can get the fully up-to-date statute with annotations and often notes through Lexis Library or Westlaw. The Home Office maintains the updated immigration rules online. I've given you the URL. Books. There is no fully up-to-date text that takes into account all of the changes that there have been. Unfortunately, major books, MacDonald's Immigration Law and Practice by the late Ian MacDonald QC and Ronan Toll, 2014. Next, The Law and Practice of Expulsion and Exclusion from the UK, edited by myself, Rowena Muffet, Ellis Wilford, 2015. The Immigration Law Handbook by Phelan and Gillespie is only a compilation of the raw material of statutes, statutory instruments, and so on. But many people find it useful. Halsbury's Law to you have access to it also. So that brings me to the end. Thank you very much.